That's what I spent my afternoon doing yesterday, was reading jail reports. I spent more time on jail reports than I did PSIs.
They're more voluminous.
Same names I keep seeing. Good morning. Are you Jacqueline Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions, just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you? Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not going to let you guys negotiate. That I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So, again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, sir, I'm going to find that you entered a plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 2137857,
Your Honor, it's a second amended. Just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13. 13 being the offense he's already pled to.
so you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And count 20
right.
reads motor vehicle. That's incorrect, Judge. It's evading on foot with priors.
Okay, gotcha. So this shows that you were placed on probation August 29th of 2022 for evading with a vehicle, and that was a 10-year sentence in prison that was probated for 5 years. Is that correct? And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true? True. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? True. And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true? True. What's the status of the possession and the failure to ID from that date.
I believe the failure is, I think, still pending. The misdemeanor.
The failure ID is still pending next door.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay. Let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation. One of the allegations. So I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery. You think community service is slavery? Do you think that? It's the same. I'm not taking 5 on the MTRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more. But that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different. But I'm not going to do that. All right, so we are back on the record in cause number 21-37857. And again, you're Jacqueline Young, right? Sure. And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the
new agreement is 8 years TDC.
All right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, sir.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis? Speak up. And do you fully understand them also? Yes. And I have made the notation with everyone's agreement on the agreed punishment recommendation page that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank you.
All right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yes.
Okay. It can still go worse. I mean, I got 2 more years. It's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before. All right, good luck to you. You can go back with the bailiff. I did it again. Y'all have got to make me stop. I just did my mouth thing again, my frustrated thing that they keep catching me off. I can't help it. It's what I do when I'm frustrated.
You know what?
Look, my face is turning red right now. All right, you're Christopher Bushnell? And so Mr. Bushnell has two cases, an evading arrest or detention with a motor vehicle and engaging in organized criminal activity, and cause numbers 25-0112 and 0113. There was previously an agreement motion, and a plea agreement for 10-year deferred probation. We were here because of the issues in the jail. I rejected that because if I were going to go along with that, I was going to order the ISF. And so we're back here. And then, so let me ask you, I should tell you what's bad is when I remember stuff, Mr. Bushnell. Your birthday's in October, right? No, December. So we're getting close. But here's the problem, Mr. Bushnell. So you were here May 6th, right? And I didn't accept these plea agreements, and I got pretty upset with you because of what had been going on in jail, right?
Yeah.
And what did I tell you?
Back with no write-ups.
You know how many write-ups you've gotten since May 6th? You want to take a guess? Too many to count. Too many to count. May 6th, you got, since then, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 more. Fighting, same things. Fighting, not following the rules, calling names. I mean, same thing. You don't like following rules, do you?
I do.
You do? What part of calling a correctional officer the names that you've been calling is appropriate? It's not. So why would you keep doing it after I told you? I told you, go just be good for a month. 1 month, be good, follow the rules. And it's one thing if you've got another inmate running up on you fighting and that was your excuse, but it's not. I'm not accepting any plea agreements. If the jury wants to see all this and give you probation after that, that's going to be up to them. I'm not doing it. Go back with the bailiff. We'll set your case for, well, let me do this. Ms. Holmes has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, I'm looking at it over and over, calling them the B word, not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff. Good luck, Ms. Holmes. All right, so you're Bryce Thomas. And Mr. Thomas was previously in court, entered pleas of guilty in cause number 24, DCCR 0389 to the third-degree felony offense of prohibited weapon. Cause number 24, DCCR 0390, also a third-degree felony of possession of a prohibited weapon. Cause number 24, DCCR 0391, pled guilty to the state jail felony offense of theft of a firearm. Cause number 24, DCCR 0392, pled guilty to the lesser offense of indecency with a child by exposure, also a third-degree felony. There was no plea agreement. I have received and reviewed the pre-sentence report. Has everyone had an opportunity to review that report?
State action.
In addition, there is also the largest packet I've ever received of jail incident reports in a case. Did everyone have an opportunity to review those?
Yes, I took an evening and
35 pages.
I
Yeah.
reviewed them one evening good.
State reviewed all 35 pages.
In addition, the state has filed a state sentencing memorandum. Mr. Burbank, did you receive that and were you able to review it? Okay. Anything else, any objections or corrections or additions to the report?
No, Judge.
All right, Mr. Burbank, you may proceed.
Your Honor, this is a very young kid that in a very short period of time, stripped off the cliff. And got himself in a lot of trouble. I will represent to the court that I was encased by his family. One of my issues was the recovery of the weapons because they were law enforcement. I will represent to the court that conveniently, mysteriously, weapons ended up in my office in the front hallway and were returned to the sheriff's department. And I'd like the court to take notice that those weapons are off the street and back into the department.
Could you speak up a little bit, please?
Back into the department. We go open because I do not have a recommendation. You can place him on probation for a period of 10 years and see what he does. These are third-degree felonies that I can do. At the very end, state jail has the theft of the firearm. You could put him in a state jail for the period of time and put him on probation for the other one. I would ask that if you are going to start him to the penitentiary, that maybe in the reference to the sexual offense, if you do place him on probation, so that we can have some accountability for him once he got out for a period of time. That would give the court maybe whether or not he's learned his lesson. Now, as you peruse through the 39 pages of incident reports, and I'm not trying to be funny, but I've talked at length with Mr. Thomas about those, and he'd like to address the court on those. It is what it is, and that's not behavior of whether or not he would be able to follow the court's orders if you can't follow what's going on in jail for a period of time. Reference to probation. I would ask that the court would ask Mr. Thomas.
Yeah, go ahead. You have something to say?
What do I have to say? I could just say it's just young, dumb, just being in jail at a young age and not really knowing what I said. I got write-ups.
Yeah, but once you get several write-ups, the whole point of growing up is to learn from your mistakes. So if you keep getting write-ups, then you can't just say I'm young and dumb, so I keep getting write-ups. I don't disagree that you're young and dumb, but this is ridiculous. I know our jail cannot wait for you to get out. Cannot wait. Mr. Coleman?
Yes, Your Honor, I'll be brief since I put everything, I made the state's position clear in our sentencing memorandum. I'd like to briefly shift the focus from the write-ups to the underlying facts in the state's position.
Yeah.
I believe are
Stealing out of cop cars.
stealing from patrol vehicles, at least 2 patrol units, Your Honor. Detective Matt Dixon is here if you want to hear more details of the detective. But Your Honor, I think the audacity, the boldness to steal these weapons from a police car goes to show what exactly the nature of this defendant is and what we're dealing with here. And even more than that, Judge, it appears from the underlying facts that the defendant may be implicated in a series of other car burglaries. We've got a Glock switch that converted one of those weapons into a fully automatic weapon. He was conspiring with another juvenile, a 16-year-old, to steal the weapons, which a photograph is attached to my sentencing memorandum if you've seen it. This was nothing less than an arsenal that these kids amassed, Judge. I shudder to think what could have become of these weapons if they would end up in the hands of other criminals, if they could have been used against law enforcement, Your Honor. Long gone are the days where there's a low caliber Saturday night special that these kids use, you know, in some type of crime. They are loaded for bear with fully automatic weapons. I'd ask the court to make an example out of this defendant. He benefits from not having a criminal history to speak of, but Your Honor, this is beyond the pale. I'd ask you to send him, do two things, a split sentence in this case. Sentence him to prison for what he's done, and then following that, a consecutive probation period so that we can continue to monitor him and supervise him after he's released from prison. Thank you, Your Honor.
So I wanted to make sure, Mr. Coleman, I've done this type of sentencing that you're asking for on some different cases. I think the probation period, if I sentence him to probation today, I don't know that I can make that consecutive. So I think
I believe you can, Judge, and if you need to recess this proceeding, I can get you case law in pretty short order. I think
because when would it start?
it will start after he finishes his period of incarceration.
Okay. So whatever I give him, if I do prison, and then I say it's consecutive with a probation, and does it matter if it's a straight or a,
I don't believe so either, Judge. But again, I'm happy to get you some cases.
No, I appreciate the idea. Again, we've done it sometimes. I mean, what are y'all doing? What are you doing with all these?
In Texas, a judge.
Not shooting people.
Sir?
I'm not shooting.
Not shooting people yet. What are you shooting? Why would you have these? What are you getting these to shoot at? Just to be tough and say you have guns? That's all that's happening with these guns on the street is y'all are shooting at each other, at other people, at houses, at cars, at whatever. There's no reason to have these kind of guns. These aren't hunting guns, right? You're not going to shoot a deer. Do you hunt?
I do.
Do you?
Before, but
Have you? Which one of these is your hunting gun?
none of those.
You thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. Here's what I'm going to do, because I agree with Mr. Coleman. I would like, at least in the indecency case, to get treatment and probation on that case so that we know you're not going to go make that type of bad decision again. But I'm not giving you probation on everything. You want to change your life and do better and not be young and dumb, you're going to have some time to figure that out. So in cause number 24, DCCR 0389, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Mr. Coleman actually asked me to sentence you to 5 years. I don't think that's enough. I'm going to sentence you in that case to 7 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time you've been in custody. And part of the reason I made it lengthier is because you have been in custody so long, and a 5-year sentence really isn't going to amount to much. Cause number 24, DCCR 0390, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 0391, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then in cause number 24, DCCR 0392, find sufficient evidence to find you guilty. However, in that case, I'm going to defer all proceedings, place you on probation. No, that's the third. I'm going to find you guilty of that offense, sentence you to a term of 10 years in the institutional division, but I'm going to suspend that and place you on probation for 10 years.
Can I address the court on that?
Mm-hmm.
With a deferred, though, with the registration, it would, if he did comply after he got out, that he may have a chance instead of a conviction.
He's already got 3 convictions.
Well,
A
I
fourth.
understand that, but a sexual, kind of,
May I respond, Judge? That is a reduced plea to a reduced charge.
I agree.
Want to ask?
Can I give a straight on any decency though? Hold on. I think it has to be deferred. Hold on. Yeah, it has to be deferred. Okay, so I'm going to go back in that cause number, which ends in 0392. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and I'm going to place you on probation for 10 years. That will run consecutively to the other cases. So that probation does not start until you get out of prison. Then, if you violate that probation, you could be sentenced up to 10 years in that case. So you're going to be under supervision or in custody for a very long time. So if you really want to change your ways, you're going to have every opportunity to do that. If you don't, you're going to end up, number one, you're probably not going to make parole if you keep acting like you've been acting here. If you get to prison and you act like this, you're not going to make your parole. You're going to do that whole 7 years. That's going to be up to you. The sooner you get out and act right, the sooner you can start this other probation and get off of it, grow up, and maybe change your life. That's going to be up to you. On that deferred, I am going to order a $500 fine that you follow all of the conditions of probation. That's going to include sex offender treatment, going to whatever classes are necessary, staying clean, not getting in any trouble, all of those kinds of things. Do you understand? Mr. Pullman?
Your Honor, is there a deadly weapon finding option with the weapons?
I don't think so.
Okay. Okay.
Unless you can, I don't think that's,
Within the legend.
well, and they're not, possession of it prohibited in the 3G. So I don't think we can.
Okay.
Yeah. All right. So all of these are actually wrong because y'all marked off plea bargain and there wasn't a plea bargain. So I'm going to hand you the trial court certification in all of your cases. This shows that these were not a plea agreement.
it was a plea agreement, Judge, because there's a, no.
Oh, because of-
No, there was an unauthorized use that we agreed would be dismissed.
And also the lesser offense in that. So there was consideration taken. So this was an agreement, at least for those reductions. Okay. So you have waived your right to appeal. In these cases, I'm going to hand you those certifications. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. You can go back with the bailiff.
I thought
Yeah.
we have Mr. Jenkins that you're going to.
That judge doesn't play games. You come into her courtroom with attitude. She sends you back with more years. Jay and Young thought 5 years was a deal. He left with 8. Christopher Bushnell thought probation was still on the table. He's going to trial. 11 write-ups in 1 month. 11. The jail behavior. The names. The I don't care. It all followed them right into that courtroom. The lesson? Judges are watching. Every write-up. Every outburst, every disrespectful word. Actions always speak louder. Subscribe for more real courtroom moments where attitude meets consequences, and consequences always win.